Hey guys, it's Karalynn. Welcome back to the podcast. And today we're going to talk about termination for convenience clauses and what happens after termination for convenience. Now, this is mostly for commercial subcontractors that sign subcontracts with termination for convenience clause. So, first off, what is a termination for convenience clause? It is a provision mostly in commercial subcontracts that would allow the general contractor to terminate the subcontractor for any reason or no reason at all. So the general rule in contracts is that unless there's a default or somebody has breached the contract or done something wrong, you can't just cancel the contract, right? This is a way around that, meaning the sub doesn't have to have done anything wrong. The GC can just decide to cancel the contract and not tell them why, right? They don't have to. They're just saying, I'm terminating the contract for convenience, right? Okay, so why do termination for convenience clause even exist? So the reasoning behind a termination for convenience clause is that if I decide to cancel your contract, you're not in default for no reason, I would be in breach of contract, right? So I, the general contractor, terminate you don't give you any reason, just say you're terminated. I'm in breach of contract. And what that opens the general contractor up to is damages owed to the subcontractor, right? So I, the general contractor, just terminate you without any reason. My contract doesn't allow for that. I don't have a termination for convenience clause. I, the general contractor, now owe you, the subcontractor, the profit that you would have made on that job, right? And so there's damages involved. So what the termination for convenience clause does is it allows the general contractor to terminate the subcontractor and not face any damages, right? The contract says that I, the general contractor, can terminate you for any or no reason, and I don't owe you anything, right? So there's basically the general contractor can never breach the contract because they would just terminate it for convenience, right? And if that happens, I don't owe you anything, right? So they get out, they can terminate the contract for no reason and get out of paying the subcontractor damages, right? And so and the other reason why it exists is that if they terminate you for cause, right? So if they terminate you for cause, like in this example, they ordered you to do this extra work, right? And you said, no, it's not extra work. And they said, yes, it was. And they terminated you because you didn't do it. And we go back and find out, hey, yes, it actually was extra work. That means the termination for cause was no good, right? And they're like, okay, fine. Then I just terminated you for convenience. It doesn't really matter, right? So it allows them, if they wrongfully terminate you for cause, to slip into the termination for convenience and not face any penalty for wrongfully terminating the contract. So it's great protection for the general contractor. It kind of screws the subcontractor, let's be honest, right? Because the flip side of that is that you, the subcontractor, do not have the right to cancel the contract for no reason. Once you sign that subcontract, you are on the hook to do that work for that price. And if you don't, and you try to terminate the contract without cause, and just walk the contract, now you are liable to the general contractor for whatever it cost him over your price to complete your scope of work, right? So, I've seen it happen several times, especially during COVID. We signed a contract, before COVID hit. That doesn't get started till after. Things have substantially changed. One of them was a roofing contractor that I had. He's like, he didn't honor the contract. He didn't come to me till afterward. He didn't honor the contract. They hired somebody else. It cost them $100,000 more for that same scope of work that he was willing to do before COVID for $100,000 less. He got sued for the difference, right? So you as a subcontractor do not have a termination for convenience clause in your contract unless you negotiate and get it in. That means you cannot cancel the contract without facing damages. So if you signed a subcontract and you want to try to get out, or you need to change something, give me a call. We'll talk about options, but generally you can't just terminate for convenience like the general contractor can terminate you. So termination for convenience in the real world obviously happens in one of two situations: before work starts and after work is started. So before work starts, normally in this situation, the general contractors found somebody cheaper to do your scope of work, and they just terminate your contract before you even start. And so in that situation, most of these termination for convenience clauses are built the way that they don't owe you anything, right? They don't owe you anything for materials you may have ordered. They don't owe you anything for mobilization costs. They don't owe you anything for design. They don't owe you anything for anything you did on the project, right? So if you get terminated for convenience before you even start, you're basically just out of luck, right? And whether you could file a lien for that stuff would really depend on your particular state. But generally speaking, if you're terminated for convenience before work starts, you're not entitled to anything, right? And even like I said, even if you ordered specially fabricated materials that you can't return, you're kind of on the hook to pay for those as well. You could try to sell them to the GC to use with his new contractor, but you're not entitled to pay for them, right? Okay. So say you're on the project, you're in the middle of the project, and all of a sudden you get a termination for, as a letter, it says you are hereby terminated for convenience, no reason at all, get off the job in 48 hours, leave all your stuff. Seen that happen too. So what happens in that situation? In that situation, you are entitled to be paid for the work that you already did, right? But you're not entitled to lost profits. You're not entitled to recover anything for the open hole in your schedule or anything else associated with the project that you would have that would be in the future, the profit you would have made, the work that you were supposed to complete, that dollar amount. You're not entitled to any of that. So basically, I usually don't see termination for convenience in the middle of a project that often. It usually happens beforehand, but it has happened in the past. So you are entitled to be paid for the work you haven't done. If they don't pay you, you can file a lien to make sure that you do get paid. So you are entitled to be paid for the work, but not anything else, not demobilization costs, anything else that they may require from you, right? So I said that's how a termination for convenience clause works. That's what happens after a termination for convenience clause. Not very good outcome for the sub. But so a lot of general contractors and project managers think that they have this termination for convenience clause in their contract, right? And most of them do, but some of them are not written very well. So I recently had a case where a general contractor tried to terminate a subcontractor for cause, but it turns out the subcontract didn't really have a termination for convenience clause. It really only said that you could terminate for cause. So when they terminated, they didn't give them any reason because they didn't have any reason to terminate because the general contractor found somebody else to do the work for cheaper in that case. So the general contractor was on the hook to pay the profit that the subcontractor would have made on that job. All of that to say, they said, yes, most of these contracts have a termination for convenience clause. And that's what it means if they're properly written, is that they can terminate you for no reason and not have to pay anything, right? But if that happens, let's actually have a lawyer look at the contract, right? And see if the language is correct, if they can do what they did, right? Or if there's other provisions around it, you just never know. They're set up to work the way I explained. The whole purpose of them is to allow the general contractor to basically change their mind and hire somebody else with no penalty, right? But if they're not written correctly, the sub could still have rights to be paid profits and or rights to lien for the work that they did. So there are things to consider, even if this happens, even if this is in your contract. But hey guys, this is just one of the many provisions in these commercial subcontracts that even if you don't want to negotiate the subcontract, understanding what they mean and how they work so you can evaluate the risk is huge, right? It's like you're getting ready to sign a subcontract. You see the termination for convenience clause. Okay, you know it's there. Maybe you try to get them, hey, if you guys got the right to terminate for convenience, I want that same right. It's a way to negotiate. Or maybe you negotiate it. I don't want to sign the contract. I don't want to take the risk of being terminated for convenience. So if you want me to do this job, you're going to have to take that out, right? And so it really depends on your risk tolerance. If you've worked with a general contractor before, a lot of different variables. But it's so important that when you sign these subcontracts, you don't just sign them. Even if so we do contract reviews on a flat fee, 5 business day turnaround. All we need to do is 2 or 3. And I can tell you what these same provisions are in every subcontract. I can tell you what they are, and I can show you how to spot them, and you can do it on your own, and I can help you negotiate. But just signing them, not knowing what they're saying or not knowing what the risks are is very dangerous, right? Like I said, again, I've never seen a good project. I've only seen a bad project, and I've only seen the damage that can come from these terribly one-sided subcontracts. And so trying to give you guys the tools so you know how to negotiate and what to do, right? So that's termination for convenience clause. What happens afterwards? If it happens, guys, give me a call. We can talk about different options. I have free consultation for 30 minutes. It doesn't cost anything. I can at least give you some ideas on where to start. I'm pretty good at solving problems or creating leverage or at least putting you in a better position. So, hey guys, reach out to me if you have any questions. I'm on social media, thecromeslawfirm.com. I look forward to working with you. Thanks.